Hi, my name is Akiva Goldman. I'm the director and founder of Goldman and Associates. Our firm has a primary focus on family law issues here in Michigan, and today we're going to continue our video series designed to educate and inform the public. So please subscribe to our channel. Oftentimes, in our changing society, where things that are used to be considered, out of the ordinary are now commonplace, the question becomes whether or not somebody's custody rights are jeopardized or potentially denied because of lifestyle choices that people make. The answer is quite simple. It can become complicated because you can get an overcomplicated set of facts and get bogged down in the details. Let's remember one thing. The court's going to determine custody based on what's in the best interest of the child. If one's lifestyle choices impede the best interest of the child, if they somehow interfere with the best interest of the child, if they militate against the best interest of the child, if that's happening, then yes, the court can deny or modify custody based on lifestyle choices. Now, lifestyle choices could be all sorts of things. It could be, for example, whether or not parties decide, I'm going to vaccinate my kids. I'm not going to vaccinate my kids. These are choices that I'm making. Could they impede custody? Well, it depends on the judge. It depends on the circumstances. It depends on the child. If somebody says, my lifestyle choice is to be high on drugs all day, will that impede custody? Yes, it will. But it won't be because you've chosen that lifestyle. It'll be because it's not in the best interest of the child to be in an environment where people are smoking weed all day and getting high. So lifestyle choices become very important, but only as it relates to what's in the child's best interest. The court doesn't really care about you. The court doesn't care about the mom or the dad. The court feels that adults are responsible for themselves. It's the old expression, you made your bed, you lie in it. You've made choices and you are bound by those choices and you've got to deal with the consequence of that. But your kid doesn't have to. And that's really the key. If you've made a lifestyle choice that you want to, for example, deny your kid the opportunity to be educated because you feel that homeschooling is the better route, again, the court's not going to take away custody because you've chosen to homeschool. The court is going to take away custody if you've chosen to homeschool and it's contrary to the best interest of the child. It could be that the court feels the child needs more socialization. It could be that the homeschooling isn't working and the kid is not at par where he or she should be in comparison to a regular kid who's going to stand in public school. So these are things, but the point should be clear. The court, if it denies or modifies custody, it won't be because it does not believe that you have the right to make your lifestyle choices. The court certainly upholds an individual's right to choose whatever lifestyle they want as long as you're not a criminal. But the court will not allow the child's best interest to be compromised because you made a lifestyle choice. Even if you've chosen a life of crime, if it could somehow be demonstrated that your life of crime is such that it doesn't in any way impact the child, nobody knew about it, the child didn't know, whatever, the court would have to look at that very carefully because in and of itself, if it doesn't impact the best interest of the child, it doesn't impact the custody factors that the court uses to analyze that best interest. So obviously every case is fact specific. If you have questions about your case and your lifestyle choices and how it would impact custody, of course give us a call and we'll be glad to guide you through that.